Hello, everyone. This is Paxton Bravo here from Sovos, from the field marketing team. First of all, I want to thank you all for joining us today. We're still waiting on a few other registrants for the 12 o'clock hour, so hold tight with us for a few minutes, and we'll start the webcast here shortly. Thank you. All right. Well, good morning, good afternoon, good evening, depending on where you're joining us from on this fine Friday afternoon for me. And thank you all for joining us today for the Ask Chuck Live webcast, in which we're going to be addressing the South Dakota v. Wayfair case and what it really means for e-commerce. And today, to present to you and to answer your questions, I've got Chuck Maniaci with me. He is the Director of Regulatory Analysis for us over here at Sovos. He's a lawyer by trade, but he's going to keep his jargon down a bit today. And really our goal today is to answer any questions you guys have and make sure you guys are clear on the implications of this case, where it originates from, and where it's leading for e-commerce in the world of tax. So we've got a short presentation today, only half an hour. So without further ado, I want to introduce you guys to Chuck Maniaci and begin this webinar. So Chuck, are you there?
I am indeed, Paxton. Nice to talk with you this afternoon. And of course, like every other sales tax person in the world, I'm ridiculously excited about what's happening right now before the Supreme Court. It's probably the most fun time ever to work in the space of sales tax. So let's get started. Let's get right into it.
Yeah, so moving forward, Chuck, if you just want to give a little background of who we are real quick before we move to the agenda here.
Well, sure. So Sovos operates in the business-to-government reporting space where we provide solutions. And what makes us kind of unique, especially with respect to sales tax, is that we support solutions that can be used from the smallest seller using the Amazon platform to the largest multinational corporation the largest multinational corporations in the globe. And we truly are a global company, meaning we have offices around the world, including Sao Paulo and Santiago, Chile, Atlanta, and Denver. In fact, this webinar is a cross-office webinar happening right now. And what that really does is it gives us an extraordinary global perspective and allows us to put what's happening in here in the United States with respect to sales tax into the perspective of what's happening globally with respect to the application of indirect tax on remote sales. We won't get into too much of that in this particular session, but it really helps frame up a nice understanding about what's happening here and what it could mean.
Yeah, thank you. All right, so just going over the agenda for today, we're going to do a recap of the South Dakota v. Wayfair case, and then go over the top 7 questions we received from you guys, address those very quickly, and then we'll have an open Q&A at the end to bring in anything you guys want to ask us additionally. So that being said, please feel free over in the questions tab of the GoToWebinar to add in any questions. We'll be receiving those and digesting them and answering them for you as we go. So moving on.
Okay, so let's start, Paxton, by talking a little bit about what's happened preceding this moment in sales tax history. So, and I can only give this a couple of minutes time because everyone's more interested about the future. Really what it comes down to is that back in 1992, the Supreme Court took a case called Quill versus North Dakota. And essentially what they did in that case was they reaffirmed a decision made back in 1967. And what that decision said was that based on the interest in protecting the national economy and making it available to all and having a robust U.S. economy, what they said was that it is the burden of sales tax compliance. It's unfair to place that burden on sellers unless the seller is physically present there, meaning they have people or they have property. Think of, at the highest level, think of having employees there or having buildings there. And essentially what they said was that it's not fair unless a company benefits from using the roads and bridges, and I always think about creating trash. Unless they're creating trash in the place that the jurisdiction has to clean up, it's not fair for them to be subject to the complex world of sales tax. And also what the court said at that point was that not only does the court have the ability to set this standard, but the U.S. Congress, you also have the ability, should you choose to exercise an alternate standard to eliminate that requirement of people and property. So between 1992 and 2013, Congress certainly didn't act on this, and the Supreme Court didn't take another case. In 2013, Congress finally started to take some baby steps, and this thing called the Marketplace Fairness Act passed the U.S. Senate. And essentially what the Marketplace Fairness Act did was a congressional attempt to change the physical presence standard. And there's a couple of other bills that are like that, and they're still out there in Congress. One of them is the Remote Transaction Parity Act. Another one is the No Taxation Without Representation Act. But what's important to understand there is that none of those bills got any traction besides this one bill that passed the Senate in 2013. So today we find ourselves in a situation where Congress hasn't acted. And in 2015, in a case not specifically related to physical presence, Justice Kennedy of the Supreme Court, who was a justice who was involved in the Quill case as a justice, in a separate concurring opinion said, you know what, maybe it's time for a state to send us a case where we can re-debate the physical presence challenge. And once the court said that, once states realized that the Supreme Court might be willing to revisit their Quill decision in 1992, a couple of states, including South Dakota, enacted rules that were intentionally designed to challenge Quill. So South Dakota passed Senate Bill 106. They did it with a specific intent of it not actually being enforced, but being used as a mechanism to go ahead and re-bring the issue to the United States Supreme Court. So between 2016 and 2017, the case made its way through the South Dakota state court system, and each time really was a very quick decision and said, you know what, we have this Quill decision, plaintiff wins, South Dakota law is unconstitutional. Ultimately, once it was litigated in that way at the highest court in South Dakota, the South Dakota petitioned the Supreme Court of the United States, SCOTUS, to take the case. Now, the Supreme Court has the ability to choose the cases they take largely, and they chose to take this case. And what happened after that was a bunch of people filed briefs, some in favor of Wayfair, and some in favor of South Dakota. The parties filed their briefs as well. And back a couple of weeks ago, the Supreme Court heard oral arguments from litigants from both sides, as well as the Solicitor General of the United States, so a member of the federal government who reserves the right and exercise that right in this case to proffer his opinion as to how this case should be decided. So that's where we are now. We just had oral arguments in this case.
Oh, great. So Chuck, getting to the important stuff now, what does that mean? What happens next?
Okay, well, that's where it gets interesting. That's when we get into some Supreme Court process and procedures. To keep it super simple, and I'm trying, essentially, once oral arguments are heard, usually later that week, the Supreme Court meets in what's called the Justices Conference. And I always think of this thing as it's happening with a lot of formality and pomp and circumstance. But when it gets down to it, essentially what it means is that each justice, starting with the most senior, is allowed uninterrupted time to express their opinion about the case and how it should be decided. Now, before all of that's happened, they've likely discussed the case with their law clerks and have in their mind formulated opinion, which was then informed by the oral arguments. But here at this court decision, here at this conference, they're actually articulating to the rest of the justices what their opinion is. And they'll go around the room from the most senior justice to the least senior justice. And once that's done, they'll then take a vote. And that vote essentially determines who's won the case. In this case, the state of South Dakota or Wayfair and the other litigants on the other side. And once that's done, there'll be a clear majority, meaning 5 or more justices agreed as to who should win the case. And within that majority, the senior-most justice, which could or could not be the Chief Justice, Justice Roberts, will decide who writes the majority opinion. So after that's decided, a justice will be assigned to write the majority opinion. He'll go back into his office, and over the next couple of weeks, with his law clerks, will write the majority opinion. Then the other justices who signaled that they would also be of that same opinion will officially sign on. And of course, other justices, either if they agree with the majority but for different reasons, have the ability to write their own separate opinions. And those justices that disagree can write a dissenting opinion. But when push comes to shove, what really is important is what that majority opinion says.
Okay, thank you. All right, so if we continue to move forward, this is a question that many ask about. Will I be held liable for back taxes if the court overturns Quill? What's your answer to that?
And that's a good question, and it was something that was in the forefront of the minds of the justices and the litigants when this case was being argued before the Supreme Court. And there's this constitutional principle out there that the Constitution is what the Constitution is, so you don't interpret it just prospectively, you just interpret it. So in a very technical sense, there is an argument to be made that the court couldn't simply say that this is the standard for sales, meaning physical presence is no longer required from this day forward. Really what they would have no choice but to do is say that this is actually the standard. They view Congress as having more flexibility there should they decide to do something, but technically, I think there's a good amount of consensus around that you couldn't make a rule that is specifically only prospective. But really, what the litigants tried to bring this back to practicality, and the South Dakota Department of Revenue, in making their case, indicated that 38 states have already signaled that they would not dream of doing anything that would look to try to extract tax revenue for transactions that have happened far in the past, meaning during what would be technically the open statute of limitations for tax audits, but not prior to this decision in the Wayfair case. Now, the attorneys for Wayfair and their colleagues said that there is reason to believe that this could be done retroactively, and they point to like one letter, and truthfully, it is just one letter written by a Connecticut Department of Revenue official, where he appeared to be making an argument to the taxpayer that they are actually liable for back tax. But I think what's important to understand here what's really more important to understand here is that there are a bunch of states that have created rules that are contingent upon this case being decided. So whether or not retroactive liability is a concern, I think there is an immediate concern for prospective liability. Stated another way, a lot of states are ready or have already changed their law to tax remote commerce immediately once the court, if the court opts to overturn Quill.
Okay, so adding complications, great. All right, so moving forward, have states done enough to simplify sales tax to this point?
Yeah, and again, this is something that the justices were very much concerned about. Usually when you think of a court case, really what's supposed to be front of minds for judges is how this rule, what is the correct legal result for the parties in front of them. The Supreme Court has a different state of mind, and usually they only take cases that involve issues of national importance. So while they evaluated the South Dakota law, they really were far more concerned about what would happen in the rest of the country should they opt to overturn Quill. And there were definitely arguments on both sides. The South Dakota Department of Revenue pointed very clearly to the 24 states that have joined something called the Streamlined Sales Tax Initiative, and what they've done over the last 15 years in terms of providing a very simplified taxpayer registration process, providing a very simplified tax return, publishing boundary files and rate files so that sellers know what tax to collect and when, requiring 60 days notice before a change in rate can be made official, providing these very nice and clear uniform taxability rules so sellers can know what's taxable and what's not taxable in a state. So that's actually a lot of work that's been going on to simplify sales tax since that 1992 case. But the respondents, the Wayfair folks, would point to the fact that, well, that's only 24 states. There's the rest of the country. And the rest of the country includes places like New York and California and Pennsylvania. And there's an argument to be made that they haven't really thought about or changed their laws to indicate what national collection would look like, and really haven't made things as simple as they could be in a way that enables far-flung companies from across the country, maybe across the world, to reasonably comply with their sales tax.
Okay. All right, Chuck, got another question for you. What about the small sellers?
So this is another really interesting point, and again, something else that was talked about at length by the justices and the litigants. And it's interesting to think about this in the framework of South Dakota's law. What South Dakota said was that any seller who has 200 sales into South Dakota or has $100,000 in transactions to South Dakota customers would be liable to collect and remit their sales tax. Now, compare that to what was contained in that marketplace fairness bill that we mentioned a little bit earlier. That standard was actually far more inclusive of what would constitute an eligible small seller. And in fact, I think it had a threshold in the neighborhood of $1 million. So really, the Congress was looking to exclude far more small sellers than maybe South Dakota was. And really that prompted a lot of debate amongst the justices about what truly protects small sellers. Do we need to be concerned about protecting them from complex and unsurmountable taxability rules that they would have to be compliant with? Or does protecting them mean that we're enacting a law that puts them on the same playing field as everybody else, meaning a small internet seller selling around the country, is it fair to put on him the same obligation as a brick and mortar company in that same state? Should they be doing the same thing? Should they be both charging sales tax, or are we putting these small internet sellers effectively out of business by making them required to comply with sales tax? There wasn't an easy answer to that question, certainly the view of what best serves small sellers is something that's going to weigh on the minds of the justices as they make that decision.
Great. Thanks for clarifying. Let's see what we got next. Oh, good. This is good for us to answer and for people to know. What role will software play in this whole ordeal with the overturning Quill and the upcoming, South Dakota v. Wayfair? So how does that change for tax?
Yeah. And of course, we have a little skin in the game here as a software solution provider for the smallest market, to the smallest seller, to the largest multinational enterprise. And one thing that I think the court was frustrated with is that both sides of this litigation presented very different representations of reality. And in fact, I think at one point, Justice Breyer from Massachusetts was particularly annoyed, where he's like, I read the South Dakota brief and I said, absolutely, we need to overturn Quill. I then read the Wayfair brief and I said, absolutely, we need to leave Quill in place. And part of the thing that frustrated him was his understanding about how manageable and affordable software was. And the parties to the South Dakota were quick to point out that software can be as cheap as $12 a state, or $12 a month for a limited number of transactions. What the other party said was, well, not only is it not that cheap, but then there's the implementation cost and the cost of audit compliance, which software doesn't even necessarily support. I think both sides really had too simple a argument there, meaning they didn't do themselves justice by not squarely representing the situation head on. And I think when you represent the situation head on, and again, I'm a bit biased in this, is that software is indeed available and affordable. I'm not saying it's free necessarily. I'm not saying it's super cheap, but it's affordable and scalable based on the nature of the seller, how they sell across the country, how many different types of products they offer, how complex their transactions are. So, states, the justices will definitely wrestle with this, and I think to some extent they don't really necessarily have, at least based on what the litigants provided, a super fair picture.
Okay, thank you. Let's see what we got next for you. What should e-commerce business be doing right now? I guess that's what everybody's asking, right?
Okay, yeah, this is an important question, and there's it's funny, the justices argued about whether their role here was binary, and that's a computer term and not a legal term, so it's fair. Either these saw themselves as doing one of two things: completely overturning Quill and creating a rule that says any sale in any state creates an obligation of that seller to collect and remit tax, meaning that states could, should they so choose, enact rules that are even more stringent than South Dakota's. So it could be one sale and $1 of revenue rather than 200 sales with $100,000 of revenue. And alternatively, they could leave Quill as the law of the land. I think it either happens, e-commerce businesses are going to be faced with a new reality. Either they'll have an expanded obligation, or what they're going to see happen is that states are going to double down on all the things they've done to date to try to nibble at the fringes of the Quill doctrine, try to get as many e-commerce sellers within the ambit of their sales tax rules as humanly possible, enact things like notice requirements like South Dakota, like Colorado has, or cookie nexus like Massachusetts has, and really try to get e-commerce in their clause, if you will, in some way, shape, or form under existing doctrine. And what serves business in that sort of framework are a couple of things. Number one, they should really take time to take stock of what they sell, where they sell it, and how they sell it. Now that sounds simple, but when you start dealing with multi-channel retail companies or other manufacturers that sell through multiple channels, that answer isn't necessarily as easy as you would think. But having that answer in the back of your mind allows you to evaluate what you would need to do if Quill is overturned and how you should consider your liability should a state enact a cookie rule like Massachusetts or taxpayer notice provision like Colorado. What's my liability? How do I need to react based on what my business's footprint looks like? The other thing to keep in mind is, do I have technology in place that would allow me to scale with ease where I'm collecting tax? And truth be told, that's one of the great things about a technology solution, is that it's scalable. You set it up for a couple of states based on your current tax liability footprint today, but should that expand based on either an overturning of Quill or a state enacting a rule that tries to work within the framework of Quill to get you, you can simply click a couple of buttons and start to collect tax in those states as well. The other thing to think about is, how are you going to handle audits? Do you have functionality in place that allows you to extract transactional data and share that data with a state regulator in a coherent and readily understood format in the event of a sales tax audit, or is a sales tax audit going to mean a bajillion hours of work for you? Okay, so in terms of what happens next, what's likely going to happen next is that sometime in June, because the Supreme Court, now that they've heard the case, has to make a decision that usually will be announced towards the end of their term, most likely in June. So Paxton, are you there?
Yes, I'm here. Wow, the really is muted. Anyway, I was going to say, so June is the date to remember. Make sure that you're prepared.
There will be a decision at some point in June. Every sales tax expert in the country will be printing off the opinion of the court that's going to be published on the Supreme Court website, reading the last page first and going out and figuring what this means in the sales tax world going forward.
All right. Chuck, I just wanted to get to this question here from Alex Oxford. He says, is there any way for Dakota to force the hand of Congress to act, and we'll be in limbo for another 2, 4, 20, 100 years? What's your answer to that?
You know, Alex, that's actually a really great question. And it was absolutely something in the front of mind of the court. And I refer to this concept as government by emergency. So very much the South Dakota Attorney General, when making his case, said the Supreme Court, that the Congress has failed to act over the last 25 years because they don't want to be perceived as enacting a tax hike. And the way that you can change that framework is if the Supreme Court overturns Quill and does it in a way where it says $1 or one transaction creates nexus, that would potentially spur the court and change their framework from enacting a tax hike to protecting small taxpayers, and would get them in a position where they could enact a rule that would reframe Commerce Clause liability in a way that it sort of says, maybe it's $1 million in sales or $200,000 in sales, and really does something to protect the small sellers. I kind of, when I was reading that, the phrase I wrote down on my little legal pad next to me was this idea of government by emergency. Essentially, creating a rule making a decision, having that decision cause a bit of chaos, and then essentially asking Congress to eliminate the chaos by enacting a more reasonable and informed standard as it relates to the national economy.
Okay, cool. Thank you. And thanks, Alex, for sending the question there. We've got a few more. I'm just going to try to get to the ones as they came in. I've got another one here from Simchak Ganter that says, other factors like an SMLLC also get income tax nexus and needs to pay $20,000 in fees to file this personal tax return because they have investors in Amazon FBA. So their question is there any channel for a real small seller to communicate the reality of how complex this is?
Yeah, I think that is definitely a concern, Paxton, is this idea. And it's interesting because a couple of months back, the Multi-State Tax Commission tried to offer up this tax amnesty and allow sellers to register for sales tax and not be concerned about past liability. It's also sometimes called voluntary disclosure. In those states that might have enacted rules that captured you and you didn't know about it until recently, it allows you to come clean going forward by not being concerned about past liability. And in the end, not too many sellers took up that opportunity, and the reason why they didn't was because they were concerned, just like Simcha is saying, about other taxes and all the other liability that inures to you potentially if you opt to register for sales tax. That wasn't in any way discussed in the Supreme Court briefs or in the oral argument, but yeah, you're right. It's a bit of a concern.
Okay, great. Thank you. I know we're right at the moment here, but I wanted to ask one last question before we signed off, Chuck. And for anyone who did send, we have a pile of questions here. I will make sure to reach out to you guys all after this webcast concludes and answer those questions specifically. But I've got one from Kui Din that says, could the overturn of Quill not only affect e-commerce, but also to businesses making sales to other states that they are not currently registered in because have no nexus in the other state?
You know, you're absolutely right, Kui. Is that we talk about this framework and this rule with the reference point of e-commerce, and it's by no means limited to e-commerce. It is the Quill decision actually back in 1992 involved a mail order business, Quill pens. Everybody's heard of them, and there are other cases involving National Geographic and people that weren't necessarily e-commerce sellers. The ruling here would by no means be limited specifically to e-commerce. It would involve any seller who sells from another state, has no connection to that state, except for the fact that they ship items to final customers in that jurisdiction. The reason why we talk about the e-commerce framework is that in today's world, that's frequently how it happens, internet sales, but it's not limited to internet sales in that way. It's not an e-commerce specific rule. It's just the most convenient framework by which we engage in this discussion.
Great. And Chuck, I think we're running right up to time here. And I know
so I know, one thing that nobody's asked me is what I think the court will decide.
What do you think the court will decide?
So, and prognostication based on oral arguments is a very different thing. So it's funny, when the Supreme Court decided to take this case, that means at least four justices had to be interested in hearing this argument. And one would have thought that and a lot of people thought, including me, that if the states simply wanted to keep Quill, if the justices simply wanted to keep Quill, they would have denied the option to hear this case, what we would say is, in legal terms, denying certiorari. But they took the case, and when they did, almost everybody, including me, thought that this was a clear path to overturning Quill. But in reality, once oral arguments happened, a lot of commentators said, well, wait a second, there's some pretty strong oral arguments to the contrary. But I would use caution here. Often justices will ask the most challenging questions to the parties they may agree with, because they want to get the arguments framed correctly in their head and be able to articulate a legal rationale to support their decision. Now, based on the arguments, I tried to place justices in varying buckets for and against. There were clearly 4 justices in my mind, or at least 3 justices that were against, clearly 3 justices that were in favor, and the other justices are swings. And I think really what it's going to come down to in this case is probably either Justice Roberts, the Chief Justice, where he comes down. He wasn't as committal in the nature of his questions, and I think there's a good chance that he'll be the swing vote here in terms of deciding what happens in this litigation.
Okay, well, thank you for pointing out the question we needed to answer it. We're right past time here. I'm actually really happy with the list of questions we have. I'm gonna make sure I get everything answered for the audience here. And with the popularity of this, I think we can even start brainstorming for a post-decision webinar. So everybody on the webinar today, please keep an eye out for that. We'll make sure we'll get Chuck out here again and answering any questions as this legislation progresses. But I want to thank you, everybody, for coming on, and most of all, thank you, Chuck, for teaching us essentially what is going on with South Dakota v. Wayfair, and for giving us answers to the specific questions we have.
I'm happy to do it. And the other thing, Paxton, to keep in mind is that we'll get to these other questions, but if you're interested in seeing the answer, the best option would be to subscribe to the Sovos blog, and we will blog some of the answers to these questions over the next couple of days.
Yeah, couldn't agree more. Everybody,
right.
expect a replay link to this webinar so that you guys can go back and redigest it if you'd like. I'll send those out to you following this conclusion. But again, thank you so much again for joining today and asking Chuck live, and we hope to see you on the next one.